Commercial photography is an industry built entirely on the creation of images. Yet, the professionals operating within it consistently operate on flawed assumptions about who actually owns and controls that work. Physical possession of a digital file or a printed photograph is entirely separate from the intellectual property rights to that image. This schematic maps the tension inherent in any commissioned portrait. Three separate stakeholders hold competing interests: the photographer who creates it, the client who pays for it, and the subject depicted within it. Relying on handshake deals or basic invoices leaves all three legally exposed. To secure these assets, we have to deconstruct Chapter 28 of Belgian copyright law. We'll define the standard for originality, navigate dual consent portrait rules, secure strict transfer rights, and optimize your copyright tax share. Failing to understand this legal architecture invites disputes and actively disqualifies the creator from highly favorable tax treatments available under Belgian law. A photograph represents a complex intersection of intellectual property, privacy rights, and taxable income. To safely monetize it, you must address each layer individually. This is the Court of Justice of the European Union. As the highest judicial authority governing copyright interpretation in the EU, its rulings define what qualifies as a protected work. A long-standing legal objection argued that because a camera is a mechanical capture device, the resulting image lacks the element of human creation. The CJEU settled this debate in the landmark Painter judgment. The court ruled that a photograph is fully protected by copyright if it is the author's own intellectual creation. This interface visualizes the standard. To qualify as an intellectual creation, the photographer must express their personality through a series of free and creative choices. These choices begin long before capture. The photographer selects the specific framing, sets the angle of the lens, arranges the staging, and directs the lighting. The process continues through the exact fraction of a second chosen to press the shutter, the pose of the model, and the subsequent darkroom or digital retouching decisions. A purely technical shot, like an automatic passport photo or a servile reproduction, lacks these choices. Without a margin of choice, there is no copyright. Belgian courts apply this exact framework. Judges look exclusively for the trace of the creator's margin of choice. They do not evaluate aesthetic beauty or technical difficulty. A legally protected photograph is the sum total of an author's deliberate choices, imprinting their personal stamp on reality. Establishing copyright ownership leads directly to a second industry misconception: the belief that the photographer holds an unrestricted right to publish their work in a portfolio or online. This split illustrates the defining legal peculiarity of portrait photography. Two distinct absolute rights coexist within a single image. The subject holds an image right. This is a strict extension of privacy and personal data protection. It exists entirely independently of who pressed the shutter or who paid the invoice. The restriction is absolute. No one, including the author or the client, can reproduce or communicate the portrait to the public without the subject's explicit consent. This protection endures long after the shoot. It remains in effect until 20 years after the depicted person's death, exercisable by their heirs. Exploiting a portrait requires managing two separate consents: a contract for the intellectual property exploitation and a distinct authorization for the personal privacy right. Owning the copyright to a portrait provides no mechanism for public exploitation if the subject has not separately authorized the use of their image. Clients routinely commission commercial shoots operating under the assumption that paying the invoice automatically grants them ownership of the copyright. This flowchart maps the strict baseline dictated by the Belgian Court of Cassation. A paid commission transfers absolutely nothing automatically. Paying the invoice only secures material ownership of the deliverables. The client obtains the JPEG files, but they do not obtain the rights to exploit, modify, or license the underlying image. To unlock exploitation, the law requires a specific mechanism: the written assignment. Without this document, the creator definitively retains all intellectual property rights. A valid assignment requires strict precision. It must explicitly enumerate the exact media formats allowed, the geographical territory covered, the duration of the license, and any exclusivity terms. Copyright law interprets ambiguity in favor of the author. Any mode of exploitation not expressly written into the contract is legally deemed not assigned. A commercial commission without a detailed written assignment leaves the client with files they cannot legally use and provides the photographer with substantial protected leverage. Because a photograph is an original work, the income derived from assigning its rights is eligible for the highly favorable Belgian copyright tax regime. This diagram illustrates the absolute operational requirement to access that regime. The remuneration for the physical service must be cleanly severed from the remuneration for the copyright transfer. The service fee covers the physical execution. It is the payment for time spent, equipment rentals, facilitation, and physical presence on the shoot. The copyright assignment is the specific payment in consideration for the transfer or licensing of the original materials for the client's subsequent use. The tax authority demands cumulative conditions to honor this split: a genuinely original work, a dated written agreement, and highly specific usage terms. The financial split must be objectively justified. The value assigned to the copyright must be commensurate with the actual rights the client is utilizing. Applying an arbitrary percentage to every invoice without underlying legal reality is considered tax abuse, exposing the creator to immediate reclassification. Favorable tax treatment is the financial reward for properly structuring your legal contracts and deliberately separating your physical labor from your intellectual property. Every photograph moves through a precise legal journey from creation to monetization. Protection requires the documented trace of free and creative choices, establishing the author's intellectual creation in contrast to a purely technical execution. Exploiting a portrait requires navigating the intersection of the creator's copyright and the subject's absolute right to privacy. Commercial exploitation and tax optimization depend entirely on written assignments that explicitly separate the physical files from the legal rights and the hourly labor from the IP license. This video provides general legal and tax information based on Belgian copyright law and does not constitute personalized legal or financial advice. Consult with a qualified professional for your specific situation.